Good morning, everyone, and welcome to Sunday Fun Day from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Hello to everyone. Good morning, Cat Flap Carnage and Maureen from Monterey, Kathy and Cora. Who else do I see here? Joanne Moore, Jonna Moore, Shy Gal, Subi Sue, Therapist, good to see everybody here. I'm in a good mood. It's a lovely morning. Nancy says, Josh, they did it. Yay. Yes, they did. Listen, I know we got a lot of Blue Jays fans in the chat, and I am in no way going to rub this one in because that was a heck of a World Series. I honestly think if you're a fan of baseball or not, this is going to go down in the history books as one of the greatest World Series of all time. 7 games World Series. It comes down to extra innings and it's a 1-run game. Just incredible. Absolutely amazing. Obviously, I think I'd be saying the same thing, but with just a little bit different mood this morning if it turned out the other way. But congratulations to the Blue Jays. They are an incredible team. I'm sure this is not the last that we have heard of them. And that game, I think you play that same series 10 times and it's going to go 5-5. I could just go either way. You play that, you run it back again and play another 7 games in a month from now, and it easily could have gone the Blue Jays way. So congrats to the Dodgers. Go Dodgers. Big love to the Blue Jays. Incredible game. Anyhow, and hello to everybody who's here. Mr. C and Alicia K. Mayo and Farm Girl. Hello, everybody. Southern Cali B. Hello, everyone. If this is your 11th time with Courtroom Confidential on Sunday Fun Day, welcome back. It's going to be a very good show. We got a lot of great questions. You guys always amaze me every single weekend. And if this is your first time, welcome. You're in for a treat. First of all, let me introduce myself. My name is Joshua Ritter. I'm a former prosecutor with the LA District Attorney's Office. I left there after about 10 years of experience, went into private practice as a criminal defense attorney, and this is Courtroom Confidential, where we try our very best to present to you both sides of the courtroom as evenly and fairly and objectively as we possibly can, and we hope that we do that. And this is Sunday Fun Day, where we have taken your calls throughout the week. You leave us a voice message, and we're going to answer them all now live on Sunday Fun Day, and it's one of my favorites, becoming everybody else's favorites thing that we do here at Courtroom Confidential. So, as always, stay to the end. We do have some announcements. We actually have some new merch and some other interesting things we want to tell you guys about, so stick around. In the meantime, you know what to do. Take a moment, take a deep breath, center yourself, hit that like button, subscribe if you haven't already. Get us over the hump. We're almost at 60,000 subscribers. We would love for that to happen live. Wouldn't that be fun? And share this with anybody who you think might enjoy it. But now is where I have to take an active role in the show. First of all, let me say thank you to Jude Evans for gifting the membership and kicking us off this morning. That's very kind of you, Jude. Thank you. Fala Dammit has been a member for 3 months, and she says hi to everyone. So good morning to you as well. And gifting 5 memberships. Thank you so much, Fala Dammit, for the gift of memberships. All right. I think this should happen. I think this should work. Who's going to kick us off this morning? Here we go.
Hey, Josh and CC crew. This is Kelly Can't Get Right. I was wondering if you had heard about or looked into the Jesse Mack Butler case. I was genuinely interested in your take on it and to maybe shed a little bit of light to it to some of the CC crew that maybe hadn't heard of it before. If you could please give me your opinions and thoughts on the case. Thank you. Have a great day.
Good morning, Kelly. Thank you so much for kicking us off, Kelly. I love hearing from you. I love this question. I'm very interested in this case. We just don't know where you're from. If you had told us where you are located. So if you're in the chat, Kelly, let us know. If you're listening to this on replay, let us know in the comments, everybody. I do know where this lady is from. Gisela, good morning to you. Happy Sunday, everyone, says Grizzly's True Crime. Big love. Bunch of teddy bears in the chat for you, Gisela. Good to see you. All right. not heard about this case. It's a very troubling and disturbing case, and I'm trying my best. It's out of Oklahoma. I'm trying my best to reserve judgment about what the prosecutors and judges did here until we start to get some more information. But we'll tell you what we do know. And when I tell you what we do know, you will understand why I and many others are incredibly frustrated with this case. This was back in September of 2024. He was arrested. He was 17 years old at the time. He got arrested on 11 felonies and charged as an adult. Those felonies included acts of rape. Forcible. We're not talking statutory. We're not talking everybody got too drunk at a frat party and there were some misunderstandings and he didn't know, and consent is at issue. We're talking forcible, to the point that one of the young women, who both of them, by the way, two victims in this case, both under the age of 18, both minors, one of them had to be hospitalized because he had choked her to the point, according to her and according to the allegations, had choked her to the point of nearly losing consciousness. And the doctor had said she was even close to maybe perhaps losing her life. That, when I was a prosecutor, we would be seriously contemplating attempted murder in that type of a case. But it would certainly be forcible rape, and you'd be looking at decades in prison. And he was looking at decades in prison. However, in Oklahoma, they have this program called the Youthful Offender Program. And if you are under the age of 18 and you have no prior criminal history, and I don't know what other qualifications, you can get essentially a get out of jail free card. And it's an opportunity for, and listen, not to be so flippant about this, but it's a good idea in practice for legislators, especially for people, boots on the ground. Law enforcement, probably not the greatest. But what it does is it says, listen, sometimes young people make mistakes. Sometimes young people do horrific things, but that it should not saddle them for the rest of their lives with felonies. I understand that. I think we can all appreciate that. There should be an opportunity for young people who've made a mistake, even sometimes grievous mistakes, to earn their way out of that and continue to be successful members of society. But let's use a little discretion, shall we? And I don't know here if discretion was applied. I don't even know if the judge had the ability to apply discretion. And if the judge did, well, then I'm throwing as much blame at the judge's feet as anybody else. But here's the reason why I'm so upset. He was looking at 78 years in prison. Instead of getting 78 years, he had 78 years suspended so that he could do some community service and counseling. And by the time he reaches 19, he's 18, by the way. So in 1 year, you do the math, he's done. He's off for probation. He puts this entire chapter behind him. He moves on with his life with zero convictions on his record whatsoever. That does not seem like how this law, even in its most forgiving, was intended. And that is why a lot of people are upset about this one, including, by the way, the victims and their parents. This is not one of those situations where it was like, well, they were never going to get these girls to come to court. They were ready to come to court and testify about what had been done to them. Real disservice to the victims in this case. One other wrinkle, and I don't know if there's a connection. I'm just telling you the facts as I understand them. But his father is a man by the name of Mack Butler, who is apparently the former director of football at OSU. Do what you will with that information. Are they politically connected? Were strings pulled? I don't know. But I do see a young man sitting right there looking incredibly entitled about to show up to a court date where he should have been walking into prison for the better part of his life. So, Kelly, thank you so much for bringing that case forward to a lot of people who I know are curious about it or had never even heard of it. Now you know. We'll continue to follow it to see if there's any developments, but my understanding is that's how things end on that case. Thank you, Kelly, wherever you are. Next time you call in, we will definitely put you on the map, though. But let's keep it moving along here to our next case and see where that brings us.
Hi, everyone. Lynette Crick from Douglas, Arizona. I'm one of your first callers from Fun Day Sunday, but I never got on the map. So can we get Douglas, Arizona on the map today, please? And I had this question come up. And whether it's a criminal or civil trial, do the victims have to show up for the proceedings to continue? Because the guy that hurt Kata, who killed her, he had a victim before that she didn't show up, and so they dismissed the charges, which is why he was let out. And so I was wondering, if the victims' families don't show up to the trials, does that mean that it doesn't go forward? Do they have to show up? Do the victims' families have to go? Or can they just not show up because it might be too hard or because of expenses, things like that? Let me know. Thanks, everybody. Have a great Fun Day Sunday. I'll be listening. I'll be in the chat. Talk to you later, guys. Bye.
All right, Lynette, you told us you'd be in the chat. I hope you're there. If you're there, hello, good morning. And let's put Douglas, Arizona on the map. I'm sorry you never made it on the map, but now you are representing Douglas, Arizona. Appreciate hearing from you. Oh, look at that, right at the border. There we go. And a great question, Lynette. Again, I think reflecting the incredible insights and thoughtfulness of our community. And I'm blown away, impressed, and appreciative every single week. This is a great question. And it might be even a more profound question than you had realized, Lynette, but you're asking about, and I had a trouble hearing your question originally, but now I understand that you're talking about this case where a man was recently convicted of murdering his pregnant girlfriend, I think it was. And there was evidence that he had been tied to a prior case, but that victim never showed up to court, so they dismissed that case. And Lynette's question is that just how it works? If the victims don't show up, does that mean cases go away? The short answer to that is no. The longer answer to that is it's a little more complicated, and it goes to a very important case that came out not too long ago. You may have heard about this. We're going to what's called the Confrontation Clause of the Constitution. It's the idea that every person has the right, according to the Fifth Amendment, to confront those who make accusations against them, to be able to cross-examine those who are bringing charges against them. You can understand why that's important. For the longest time, the landscape of the law was that didn't necessarily mean every case, and it was kind of handled on a judgment call by the judge of whether or not it overturned the case of Ohio versus Roberts, if you really want to get into it, and that allowed judges to make a reliability call. So here's what we're talking about. Let's say you have a domestic violence case and the victim calls 911. Now, by the time you get to trial, the victim has disappeared, doesn't want to cooperate. You can't bring that person into court. Does that mean the entire case goes away? Prior to 2004 in Crawford v. Washington, we were under the Ohio v. Roberts standard. And that said, no, as long as what you're trying to get around here is essentially a hearsay issue. You want to get that 911 call in, but the 911 call is hearsay. It's an out-of-court statement, and you're trying to offer what's being made in that statement in court as its truth, because that person's on 911 saying, hey, my husband, George, just smacked me around. You want that admitted because you don't have her, so you need to somehow prove this in court. Under Ohio v. Roberts, that was usually fairly easy to do because the judge would say, well, is this reliable? Under the circumstances, can we determine that it was a reliable statement and get around the hearsay and confrontation clause issues? Crawford comes along and says, not so fast here. Not so fast. If that statement is a testimonial out-of-court statement from an unavailable witness, that cannot be used in a criminal trial unless the defendant has had a prior opportunity to cross-examine the witness. This really turns things on their tail. And a lot of these cases are now having difficulty because they cannot read that Crawford standard that says, listen, unless that person was subject to the opportunity for cross-examination prior, you're not getting that in. Now, how does that actually work in court? There's a couple of things that need to be proven. First of all, let's go back to this 911 situation. Is that person unavailable? Well, you can't find them. You've tried to serve them with a subpoena. They've disappeared. That is a quote unquote unavailable person. There is a standard for that. It's not just, they're not here, Your Honor. We subpoenaed them, but they're not here. You have to have shown attempts to actually try to get this person into court, and they're not here. Therefore, they're unavailable. But then the question really comes down to testimonial. What does testimonial mean? Because that's where Crawford comes into effect, is if that prior statement was quote unquote testimonial in nature. A testimonial statement is a statement that an objective person would expect to be later used in court. Okay, so let's think about how this might work. If you are talking to a police officer, you would expect that that's going to be used in court. You're telling a police officer, I was beaten up by my husband, and then you never show up to court. That person, objectively, we can all expect that they would know speaking to a police officer is probably something that's going to be testimonial, something that may end up in court. But what about a 911 call? Well, then it gets a little weird, because now you're saying, hey, they're not calling because they're trying to establish evidence here. They're calling for help. They're calling for medical attention. They're calling to be rescued by the police. So many times, and it's kind of a case-by-case basis, but many times in these 911 calls, they are not considered testimonial, and therefore Crawford doesn't become an issue. That was my incredibly long-winded way, because I really find this area of the law fascinating, way of explaining that, yes, Lynette, many times they do need the victim, because if they don't have the victim, they're going to have a tough time getting their statements into court, especially if they're not recorded, especially if they don't have a non-testimonial way of proving it. But it's not entirely unheard of and impossible. There are ways of getting around the current restrictions of the Supreme Court. I feel like I took a way longer time to answer that, but I hope you guys enjoyed that. And now look at all the interesting conversation pieces you have at your next cocktail party. All right, let's keep it. First of all, Laura Waldy, thank you so much for gifting a membership. Appreciate you, Laura. Let's keep it. Whoop, hold on. Kathy has been a member for 9 months, everybody. Clap for Kathy. Best channel ever. Best chat ever. Love you all so very much. We love you right back, Kathy. All right. Let's keep it rolling here.
Hi, Josh. This is Gina from Chapala. Really interesting case, worthy of John Dickinson's car, Locked Room Mysteries. Brian Shaffer, second-year medical student, disappeared from a bar in Columbus, Ohio in 2006. Cameras showed him entering the bar, but when it closed, they did not show him exiting. They could not figure out how he got out of that bar. But now the case is breaking. Very interesting cold case that's fixing to hit. And I think it's going to be extremely interesting to figure out exactly what happened. Check it out.
Love that, Gina. I love these cases that are kind of off the radar, and I learned some very interesting stories. First of all, Gina from Chapala, Mexico. Gina, I want you to tell all of your neighbors and friends there in Mexico about Sunday Funday, because you need some neighbors there. You're very much alone there in Chapala, and we don't want you to be lonely. But thank you so much for calling in. Always appreciate hearing from you. And this is a great question. I had not heard of this case. This young man right here, his name is Brian Shaffer. Back in 2006, it is everything Gina said is absolutely correct. He was a medical student at Ohio State University. April 1st, actually March 30th, he goes out with a bunch of friends, but it, turns from March to April in the middle of the night, is the last time he's ever seen. And here's some video surveillance from outside of a bar called the Ugly Tuna Bar in Columbus, Ohio. This is around 2 a.m. in the morning. Okay, so 2 a.m., the early morning hours of April 1st, 2006. Doesn't appear to be under any stress. He's kind of chatting casually with a couple of girls. Nobody had any arguments with him that evening. No signs of him being upset. I mean, when somebody usually disappears off the map, you start to look at, you dig up everything. Was this person troubled? Was this person in debt? Was this person being threatened? Did this person have enemies? On and on and on and on and on. None of those red flags come up. These women, nothing about that creates any red flags. The people that he was out that evening, none of that raises any red flags. He's last seen, as Gina said, going inside of this bar, the Ugly Tuna. He is never seen exiting it. Well, the only exit from that bar you're looking at is right there. They had surveillance on the only exits out of this bar. We have learned that there was one service entrance that could possibly be accessed by means of the back kitchen area, something like that. Maybe he went out that way. The other suspicion that they have is that maybe he left dressed in different clothes and they're missing him on the surveillance that's they're watching that evening. But his friends waited for him, never saw him again. They tried calling him. One of his friends called him every single night for weeks just to see if he would ever answer his phone. Just one of those poof, disappears stories. Gina says there's some developments in this. I wasn't finding much about it. I know that there has kind of always been a prime suspect, which is one of the people that he was out with at that time. That person has refused to ever submit to a polygraph test. I will say this about polygraphs. I wouldn't submit to a polygraph test. These things are not reliable. And I feel like they are used. I know how they're used. I know that they're used as tools to get somebody to confess. I've seen it done. I know how they work. But I also know that if you fail a test, you are forever reputationally ruined. And everybody always thinks you're a liar and you're involved. If you pass a test, immediately the narrative is, well, those things aren't reliable. They can't use those in court anyways. They never clear a person. Like, you never really hear about so-and-so took a polygraph and passed it, and therefore he's no longer under suspicion. Never works that way. Always seems to work the other way. I don't think I would ever submit to one. They're just not science. They are scientific tools and they record things. But if you're trying to tell me that can tell when somebody is lying or not lying, not going to buy it. Anyhow, there's where things stand. Great. This is a age progressed photo of what he would look like now. We're talking about, close to 20 years ago that he disappeared. These types of cases fascinate and horrify me because no forensic evidence, no blood, no attempt to contact, and no kidnapping, no murder. On and on and on and on. People just disappear, just gone without a trace. Fascinating and horrifying. Esmeralda Weatherwax says, well said about polygraph tests, Josh. It's an aspect of American justice that has always worried me. Yeah, well, that's why it's never evidence. It's not admitted into a court system because of those very reasons. So anyhow, great question. Oh, and Ann Porter, thank you so much for buying the mods of coffee. Appreciate you, Ann. Shy Gal, thank you so much for gifting a membership. I hope whoever receives that enjoys it. All right. Let me keep it moving here. Where are we going to next?
Hi, Josh. This is Linda, a new subscriber to your channel. I'm originally from Detroit, and now I live in South Florida. And I want to say hello to the CC crew and everyone who helps you with your vlogs and things. Thank you for letting me speak. And I'm asking you a question because you told me to a couple days ago. Just wanted to say, Ed, with your experience as a defense attorney, how would you counsel somebody like Donna Adelson with the unsworn statement? Would you tell her not to participate, maybe coach her to be a little more, you know what I'm trying to say, a little more, understanding where she is, maybe a little more humble? And also, would you tell her, to save it all for the appellate court? Also, if I can make a request, if you can make a t-shirt in maybe a heather gray or a charcoal gray, then I would buy one. Thank you for all you do. Look forward to everyone's question and take it easy. Bye-bye.
Linda from Detroit, as you can tell, by way of South Florida. We're putting South Florida on the map because that's where you're at right now. Thank you so much for calling in, and challenge accepted. You hear that, ladies? She wants charcoal or heather gray, and she will buy it. So we were going to find you a charcoal or heather gray shirt, Linda. We appreciate you, and we appreciate you being a new subscriber. Everybody say welcome to Linda, and thanks so much for calling in. Linda is curious about Donna Adelson, as are all of us, and what was going on with her sentencing. We all heard that statement. We all saw that it was prepared. We all saw that it did not go the way anybody was expecting, and it certainly did not sit well with the judge, as he cut her off a couple of times saying, this is not the place to relitigate this. We're not going to sit through this. That to me is amazing too, that this was prepared. This was something her attorneys had seen ahead of time. And that begs the question, according to Linda, if I were her attorney, would I have allowed this, or how would I have counseled her? And I think that kind of gets to the core of it here. I know that everybody's not the hugest fans of her attorneys in this case. I have a little bit of sympathy for them because I realized they were in an incredibly difficult spot. This is not the case that they got handed this case, right? They had to substitute in for her prior attorney who got booted off the case by the judge because of a conflict that he had prior represented Charlie Adelson. So now you've got these attorneys who, they're kind of have this case thrust upon them. They've got to handle it. She's incredibly unpopular. It's a case that the entire country is rooting against them. And on top of all of that, I think we can all agree they had a horrible client to deal with. She spends the vast majority of her time complaining about her jailhouse conditions. They got too much carbs. She's got earwax problems. I don't know. It goes on and on. I'm being threatened. I'm being bothered. You can imagine. They said they spoke to this woman every single day. That is exhausting. The amount of hand-holding and babysitting they had to do with this person. They get her all the way through the trial. She's convicted, to the absolute shock of 0 people on the planet. And now she's being sentenced. And I can almost guarantee you that when you're dealing with a difficult client, and it's all coming down to client management, they probably said to her, Donna, I don't think you're going to rub anybody the right way with this. I think you're going to offend the judge. I think he's going to cut you off, but you do what you got to do, Donna. They're done. Okay. She wants to sink her own boat. Let her sink her own boat. Their job, what they were supposed to do as far as protecting her constitutional rights, they did. So if she wants to get up there and bloviate about a bunch of nonsense and air a bunch of grievances, let them have it. I guarantee you, of all the people in that court who were happy that that judge cut that short, they're amongst them. Okay. So how would I have counseled her? I probably, sadly, would have done the same thing. Donna, this isn't helping. You're not going to look good. This isn't doing anybody any favors. The judge is not going to be happy with this, but you go ahead and do you, and please stop calling. That's how I think, and things ended up the way they did. Maybe we'll put on our heather gray or charcoal shirt. Donna, please stop calling. Can we figure that out, ladies? Get to it. Neither one of them are listening to me. They're paying attention to the chat. All right, let's keep it going here. Kaylin says, Linda P. Golan, we have a dark, we already have it for you. A dark gray heather V-neck being added to the shop soon. We'll announce it when it's available. All right, well, there you go. Look at that. They're already on top of it. All right, let's keep it rolling here.
Good morning. I'm Anne-Marie from Cape Town, South Africa. Bryan Kohberger, sorry, but I have to ask. The fact that he's now appealing the judgment on the monetary values that he must pay, which was part of the sentencing, what is the implications thereof? Does he actually now want to recant his plea to guilty?
Anne-Marie, Cape Town, South Africa, putting Cape Town on the map. I know Gisela will be happy with that. There we go. Appreciate you calling in. Look at that. Oh, there is somebody else there in South Africa. You guys need to do a meetup. A couple of people, a few people. All right, put South Africa on the Courtroom Confidential 2026 World Tour. Thank you so much, Anne-Marie. Great question. Bryan Kohberger, this is true. Recently, he filed through his attorney, Ann Taylor, a motion to have the most recent request for restitution denied by the judge. The parents of Kaylee Gonzalez and Madison Mogan had submitted expenses in the tune of $27,330. It's under seal what these expenses actually are, but according to the motion filed by Taylor, we understand that these expenses are related to travel and accommodations. I'm trying to figure out when I should get upset about this. Let me explain the rest of it, and then I'll tell you, and then I'll get upset. Stay tuned. He had already paid $29,000 to the parents of Xana Kernodle and Ethan Chapin. He also has a $270,000 fine on his head. So there's been plenty of money fined against Bryan Kohberger to the, upwards of $300,000. Their argument here is that this recent request is untimely, which it is, by the way. There is apparently a 60-day limit on when you can continue to ask for restitution. And then they're also saying, well, he has no ability to pay, that he's doesn't have this kind of money. He's in prison. He's never getting out, and therefore he's never going to be able to pay this. To that second argument, I say, who cares? That's not what restitution is concerned with. Restitution is concerned with the order being made, not your ability to pay. To the first part of that argument, I say that's a genuinely good argument. But here's where, and then they make one other point, and this is where I start to get upset. So buckle up. They say that they've already received over $200,000 from a GoFundMe page that was supposed to be helping them with their travel expenses to get to trial. Who cares? If they got to settle up with the GoFundMe people, then they got to settle up with the GoFundMe people. Bryan Kohberger doesn't get to take advantage of the generosity of a bunch of other people who are trying to help out the parents of slaughtered children. That doesn't, I don't care. None of that matters to me. If you owe the additional $30,000, then pay the $30,000, and I don't care if they've ever been reimbursed for it or not. The other thing I'll say about this is you're telling me that you take issue with the fact that the parents of children that you slaughtered had to travel and deal with hotels to be at the hearings because you requested to have it moved. These expenses were incurred because of your own arguments. You were unhappy with Moscow, so you asked to move it away. They moved it to Boise, and now because these parents have to not only deal with all of the other trauma in their lives, but get on a plane and go or travel or however they got from Moscow to Boise, which is no short trip. and then stay at a hotel just to deal with you and your nonsense, and now you're going to begrudge them that extra $30,000. Here's where I fall out on this. Is it a motion that they have legal standing to make? Sure. Should they just quietly keep their mouths shut and sit on their hands and just let the judge do what the judge is going to do? Answer to that is a resounding yes. Anne Marie from Cape Town, South Africa. Thank you so much for asking that question. Appreciate hearing from you. Say hello to all your friends down there in South Africa. Always love hearing from our international supporters. All right, let's keep it rolling here. Where are we going next?
Hi, Josh. This is Maureen from Monterey. It's another Sunday night after this morning's Sunday Fun Day, and I have a true crime item that may not have crossed your ticker tape. I'm going to read it to you briefly and then ask you a short question. Police seeking 12-year-old couple on the lam. Watsonville police Saturday were looking for a 12-year-old girl who took her mother's car and went on the run with her 12-year-old boyfriend and later was involved in a hit-and-run crash in Marina. And then it goes on to talk about the car and the license plate and call 911. It gives the name of a detective you can call if you have any leads. My question is this. Could the parents be liable for this? It's not that they kept their gun unlocked and their daughter was able to get a hold of a gun. Nobody hides their car keys, and I don't expect that the parents expected their 12-year-old daughter to steal the car and run off with her boyfriend, although maybe they should have. I don't know. But my question is, could they be liable for this hit and run? Thanks, Josh.
Maureen from Monterey, thank you so much for the question. Always great to hear from you. Let's put Monterey on the map. I gotta put this comment up from Cap Flap Carnage. I think she echoes all of our sentiments oh so eloquently. What fresh hell is this? 12 years old? Yes, 12 years old. You are right. As Maureen outlined perfectly, I'll go ahead and go through it again, though, so that we all understand. This was last Sunday out of Watsonville, California. This 12-year-old young girl and her boyfriend, who's also 12, I believe, steal her mother's car, and they go on a joyride. And they end up getting into 2 hit and runs. They flee from the scene of 1 hit and run, then get into another hit and run, and then abandon the vehicle. Now, listen, nobody ended up dead. It was kind of one of those local interest stories. It's not nationwide attention. It's fascinating because of their age. We can call it comical to some extent at this point because no one ended up dead. It easily could have turned far worse and far more ugly. But Maureen, because we have the smartest community on YouTube, asked an excellent question. Where's the liability for the mother? Because we're starting to hear a lot about this extended liability to parents, especially in situations involving school shootings where they don't have their weapons properly stored or they know that their child is troubled and access to weapons. So what about here? Does this not work out because a car isn't a traditional weapon as a gun? Is that same liability extend here? I am not a civil expert, but I went to law school a long time ago. I will give you a short understanding of whatever we're talking about when we're talking about civil liability. There's these 4 issues that you have to understand, and that is duty, breach, causation, and damages. Duty. Is there a duty owed between the mother and her daughter? Yes. She's her guardian. She has to protect her. She has a duty to her daughter. She also has a duty to the general public to not do something so dangerous that it puts the general public at in harm's way. So yes. Was that breached? I mean, you could argue, did she allow her daughter to have access Did she know that her daughter had access? That's where the breach question might become an issue. Causation. But for the breach, whenever we're talking about causation, there's actual and proximate cause. So actual cause, the but for, was the but for of her failure to properly supervise her child the but for cause of the child getting the keys and getting the car? Yes. Was it the proximate cause of the damages to the other vehicles? Well, that's where it becomes a little more iffy, because then you're coming down to the question of foreseeability. Should the mother have foreseen that her failure to supervise her child properly may have led to the child stealing the car and crashing into other people? You can see as we start to go through all of this, how it becomes much more difficult to find a direct causal link and connection between the parent and whatever failures that parent might have made and the eventual hit and run. Here's where things could get more interesting. And the articles that I read kind of alluded to this, that this may have been a troubled young woman, and this may not have been the first time. And there may have been prior instances of where they realized her behavior was at issue. That could certainly change things, right? That could change the idea of a breach, whether or not the parent should have known to keep her keys hidden, whether or not the parent should have known that she stole the car before, maybe, things like that. But end of the day, I think it's going to be a tough one. Not impossible. Doesn't mean a lawsuit won't happen. And then we get down to damages, and that's always a question of money. What kind of damages do these people who got their cars hit have? And are we talking about blood from a turnip type situation of getting that money from the mother? So, excellent question, Maureen. There's the shortest version of civil law you're probably ever going to hear on this channel, and that's the full extent of my knowledge on all of it. So, I hope that was educational to all of you. All right, let's keep it rolling here. You guys enjoying this? You having fun? We've been all over the world. We've been to South Africa, to Cape Town, to Mexico, Florida, Cincinnati. We've also had some incredible questions along the way. Forrest Nelson has been a member for 12 months. Happy birthday, Forrest. Subscribe, like, share, and comment. Thanks, Josh, Tiff, Kaylin, and mods for all the great content over the past year. You are very welcome, and thank you so much for being a member. And to Wendy Joan, thank you so much for the coffees. Keeping those mods awake and alert. Chihuahua Mamba has been a member for 5 months. I learned so much on this channel, and I quote Josh often now. I hope not. I hope not. All right. Where are we at? Now I even lost my place. All right, here we go.
Hi, Josh. This is Carolyn Mullins calling from Cincinnati, Ohio, home of the Bengals Hooday. My question for you is about Ruth Miller. Ruth is the 40-year-old woman who tossed her 4-year-old son into Lake Atwood near Millsburg, Ohio. She was an Amish woman. Her husband also tossed himself into the river, and he perished as well. This woman claims that she was giving her son to God and is pleading not guilty by reason of insanity. I just want to know your opinion about this. Does she stand a chance? Because that'd be crazy if she got off. All right. Happy Sunday fun day, everybody. Bye.
Thank you so much, Carolyn. Carolyn from Cincinnati, Ohio. Let's put you on the map. First of all, there we go. There's the map. Carolyn, great question. This is a question that fascinates me as well. So much so that we actually did a special episode on just kind of this issue that you're asking about, where we had Dr. Patrice Berry come on the show. Dr. Berry, fascinating, super intelligent, great guest. We plan on having her back again. Next time we get some sort of psychology-based question, because she what I love about her too is she really likes to stay in her lane. She knows what she knows, and I don't want to throw her, just in the deep end on any old case. So, but we had a very great conversation about this, and she's got a channel out too. You should go check it out. It's called Dr. Patrice Berry Psychologist Reacts. When you're done here, go over there, subscribe, send her some love, and send her some juice boxes. Let her know that we're supporting her and we appreciate her. There you go. There's the link. And on that episode, we talked about this exact issue. So you are correct, Carolyn. In Atwood Lake, Ohio, on August 23rd, this woman was stopped by police because she had drowned her 4-year-old son, Vincent, to death. And she had attempted to drown her daughter, who's 15, and her twin sons, who were 18, but they managed to escape. Her husband had, it looks like, drowned himself, all in the act of faith, is essentially what is being explained here. She spoke to police. This is a badge cam video. She's speaking to police, and she is not shy about what she's saying. She's telling police, I threw him in the lake and I gave him to God, speaking about her 4-year-old son. He's sweet. I love him. I gave him to God. He is real, speaking about God, and he loves you, and he is coming soon. She has now been charged with murder, and attempted murder, and she's pled not guilty by reason of insanity. And I had the question with Dr. Berry, wait a second here. Are we dealing with insanity, or are we dealing with extreme faith that we may not understand? Because people do things in the name of faith and believe things that many of us who don't share that same faith might find to be very bizarre. And I'm speaking traditionally so. There are some religions who don't believe in the same kind of medical care. There are some religions who don't believe in eating certain foods. There are some religions who believe that that in transmutation of bread and wine. Okay, does that make them insane? No. Where is that line drawn? Criminally, legally, the line has to do with a very simple question, though the answers usually end up being far more complex. But that very simple question is, because this person was either suffering from some sort of mental unrest or brain injury, were they not able to appreciate that what they were doing in the moment was wrong, either morally, legally, or otherwise? Did they not know it was wrong? And you can understand why that's the legal standard. Part of, going back to forever, we've got the mens rea and the actus reus of a crime. The actus reus, is the thing you did, and the mens rea is the mental state in which you did it. That mental state, we have said, has to include some sort of criminal intent. If you don't know what you're doing is wrong, how can you have any kind of criminal intent? And that is the question when it comes down to not guilty by reason of insanity. So it doesn't mean that just because you're saying God told you to do it doesn't really answer that question. Here's where I think this may turn. In her own words, she says, I threw him in the lake and I gave him to God. What does that mean? Does that mean to her, I knew I killed him? I knew I took his life? If she's understanding that giving him to God meant ending his mortal life here on earth, then she understands she killed someone. And does she understand killing someone is not even wrong to her, but wrong according to the law? And that's what I think this case might hinge upon. So it's a horrific case. It's incredibly sad. It's also fascinating because both of the parents kind of shared these extreme views. But we talked a lot about that with Dr. Patrice Berry. So please check out that episode and send her some love next time you see her. And thank you, Carolyn, so much from Cincinnati, Ohio, for asking the question. All right, let's keep it rolling here. Not my fault. Technical difficulties, not my fault. Don't yell at me, Kaylin.
Hi, Joshua.
Kaylin
This
yells
is
at me.
Marcia from Phoenix, Arizona, with a question about the Kouri Richins case. I'm a retired ICU nurse, and my question is, how do they know Kouri's husband was poisoned by fentanyl and not by OxyContin? And by the way, it's OxyContin, it's not Oxycontin. Contin is short for continuous, so it's OxyContin. Anyway, fentanyl and OxyContin are both opioids. How do they determine it's one and not the other? And what about the other substances that could be mixed with the fentanyl, if that's what it was? Also, what was the level of opioid? How deep did they go into this autopsy? I have questions that I don't know if they're ever going to get answered. But I'm curious. And maybe some of this will come out in when the case goes to court. I can't imagine that we know everything. So I'm happy to be part of your show. I love your show. I listen every Sunday, and I'll talk to you later.
Marcia from Phoenix, Arizona. Thank you so much for calling in. Let's put Phoenix on the map. Appreciate hearing from you, Marcia. Excellent question. I see a lot of people saying that in the comments. And the answer is, I think we're going to get the answers at trial. In fact, I'm sure of it. And you being an ICU nurse or former ICU nurse are going to be especially fascinated with that part of the trial. But yes, the levels of an intoxicant, how much, where it was, when it was found in his system, all of that kind of stuff is going to have to come out in trial when the medical examiner and the toxicologist testifies. But to answer your question about how do they know if it was fentanyl or OxyContin, here's my understanding. But maybe as an ICU nurse, you know more than me. And if you do, I'm always happy to be corrected. But my experience when dealing with autopsies and especially toxicology reports is that toxicology, it's interesting. They can't just say, here's a sample, what's in this person's blood. You have to ask to find things. In other words, you have to say, can you screen this for opioids? Can you screen this for poisons? Can you, and then you got to get specific sometimes. Are you looking for arsenic or are you looking for, what's another poison? I don't know. Some other poison. Like you got to, it's not, they can't just do these general searches and say, give me a readout of everything that's in this person's blood. So, my understanding is, especially when it comes down to even opioids, you have to screen for opioids, and then you have to do a specific drug panel asking for something like OxyContin or fentanyl. What I do know is that in this case, we have not heard testimony from any expert, but the prosecutors are telling us that he tested positive for fentanyl. So unless they are giving us a very inaccurate or misguided understanding of what that means, in my view, there is some report out there from a toxicologist that when you read it, it says fentanyl was found in his system. So I hope that answers your question, Marcia, but we will see how this all plays out. But it is kind of fascinating when it comes to these toxic, that's why many times they're saying, oh, they're waiting on toxicology. Because they can't just say what's in the blood. They have to be asking like, well, is this in it? Or is that in it? Can you test for this and X and Y and Z? Celeste Rivas with the David case comes to mind. They're waiting a long time on toxicology on that case because they might be trying to find whatever it is that may have been in her system. And maybe they're coming up with nothing. I don't know. A lot of speculation on my part. But Marcia, you're fantastic. You're brilliant. Thank you so much for asking the question. Pam Rink or Rinke, however I pronounce that, I'm sure it was wrong. Thank you so much for buying the mods coffees. Appreciate you, Pam. Keeping those mods wide awake. All right, let's keep it rolling here.
Hi, Josh. It's Jimmy McNutty. I've been watching Wendy's past testimonies, and in the first trial of Sigfredo and Katie McBanawa, the jury was allowed to ask questions. I want to know if those questions are under immunity because the state didn't ask the question. The jury asked the question. The second question I have is, if Wendi is charged and sent to trial and she chooses to take the stand and testifies, and if she says something inconsistent with her previous immunity testimonies, can they bring it up as impeachment? Thanks, Josh.
Jimmy McNutty, good to hear from you, my friend. I think I even see you in the chat, or I thought I did earlier today. One of my dudes, representing my dudes. Jimmy, good to hear from you. I love Jimmy because he is so in the weeds on this case. And I love anybody who's saying, I'm going back and watching Wendy's prior testimony. That is dedication. And that is being all in on this case. Jay, another gentleman who's all in on this case, says Wendi Adelson light just went off on my phone. He has a siren. He has a siren that goes off in his house whenever her name is evoked in the universe. Good to see you, Jay. Jimmy, put me on the map. Torrance, California. Yes, we didn't hear your location. Torrance, California. Right here in SoCal. Go Dodgers. Hope you were happy about the outcome as much as I was, Jimmy. We'll put Torrance on the map. All right. First question. This is excellent. Are the questions asked by the jurors under the same immunity protection? Because you're right. She was testifying under what's called use immunity, which means she's got a Fifth Amendment protection. She didn't want to go anywhere near that stand. The prosecutor said, not so fast. We're going to grant you use immunity, which will take away your Fifth Amendment concerns. And the judge is going to order you to take the stand. So, and remember, this came up even in the recent trial with Donna. There was some litigation about what the defense could get into or what they couldn't, because would it fall outside of the same protections of the immunity deal? And she didn't want to have to get up there and start answering questions that might fall outside of the immunity deal. So, to those same concerns, what about the questions from the jurors? I will say this. The immunity deal covers what is asked on direct and whatever doors that opens up for cross. So as long as the cross is like a traditional cross and stood in cross-examined on the same subject matter and topics as direct, all of that falls under the immunity. Where the cross could have gotten hairy is if they started going outside of direct. And that's why they were kind of put on a short leash there. Same with the questions from the jurors. The jurors are supposed to be asking questions within the same evidentiary allowable parameters that the direct examination took place. So I imagine that the judge would review these questions ahead of time and not allow anything that might affect the immunity or might affect what was asked on direct examination, and just also not allow her to be put in a position with, I mean, nobody's trying to have a gotcha here. Okay. That's not what this immunity is like waiting for some sort of mistake so that she breaks her immunity deal and they can get her. They wanted her testimony, and they wanted to be able to do that free of any kind of issue. Now, Jimmy raises another point, though, of where could she breach that immunity deal? And that is, what if she gets up on the stand in her own trial, if she's arrested and Jay's alarm goes full-fledged nuclear in his house, and she is indicted and she is taken to trial. What if she lies? What if she gets on the stand and says something else entirely? This is going to blow your mind a little bit. There was a case from 1979 called New Jersey versus Portage, where this exact situation kind of came up. In that case, it was a kind of a political official was indicted. They gave him use immunity for the grand jury. He asked if he was going to be cross-examined on those statements if he testified at his own. He was later then indicted, so he went to a grand jury for somebody else. He was later then indicted, and he asked the judge if he could be impeached by his prior statements that he testified to during the grand jury, and the judge said yes. And because of that, he didn't testify. The Supreme Court came back later and said that's not right. That was compelled, coerced testimony during the grand jury. You can't use that as a tool and a sword against that same person. So the most recent case on this was from 2022 called Hemphill versus New York. I'm going to read you a quote from that case. Thus, in New Jersey versus Portage, the court rejected a state's effort to impeach a defendant through the introduction of his own coerced testimony. It did so despite the strong and obvious interest in preventing perjury, because the very introduction of the coerced testimony would violate the Fifth Amendment's provision that no person shall be compelled in any criminal case to be a witness against himself. So as strange and as bizarre and as outrageous as this may seem, Jimmy, she can get up and lie as a lying liar and say something very different during her own trial if she were to be indicted and testify than what she had said previously, and they can't use that against her because that is considered, has considered to be of a coerced testimony from those prior immunity grants, and that we're saying would be in violation of the Fifth Amendment, and that's more important to us than perjury, is essentially what it comes down to. We're going to allow perjury if it means protecting a person's Fifth Amendment rights. And if you think about it, defendants, when they get up and testify, lie a lot of times. Always, it's just we don't know that we don't have their prior testimony under sworn testimony. So there you go, Jimmy. But end of the day, what is she going to say all that different? I mean, she's denied involvement. She's denied knowing about it happening. She's denied being part of the planning. She's probably going to say the same thing if she testifies anyways. Anyhow, I am sure Georgia is just getting all her ducks in a row, says Chihuahua Mama. I'm sure you're right. Somebody give Georgia a call. Tell her, get it going here. We're getting impatient. Great question, Jimmy. Good to see you, Jay. Torrance, California will put you on the map next time. Let's keep it rolling. All right.
Hey, Josh, Tiff, Kaylin, and CC crew. It's Shell from Northwest Florida. The other day I was reading an article and I got to a sentence that it just really confused me, and I thought I had the players mixed up, so I went back and started over, and that wasn't the case. So I just chalked it up to bad reporting and moved on. Fast forward a couple days, I came across the same concept. So there was a dude arrested and assigned a cell in a local jail. Shortly after arriving to his new cell, his cellmate allegedly beat the crap out of him and he eventually died. But here's the part that gets me. The alleged assaulter, aka the cellmate, was ruled, and I quote, ineligible for bail due to the charges. Due to the charges. What about the fact the dude's in freaking jail? Why would bail even be an option? The only thing I can think of is that if he was close to a release date, he might have still been able to be released and just out on bail if this crime that he committed, allegedly, behind bars wasn't something violent like selling drugs to another inmate or whatever. I don't understand how a person in jail could be eligible for bail. Side note, the man that got killed was a dude from my hometown and in jail on a simple DUI and winds up dead, so yet another reason to not drink and drive. As always, thanks for all you do. Bye.
Shelly, so great to hear from you. Appreciate you. Let's put Northwest Florida on the map. And a great question. It was kind of a Shelly rant there for a second. Shelly says, why are we worried about a person who's already in prison getting bail set on them? Doesn't it seem like we're, what do they say it? Swabbing the deck of the Titanic or something. Well, there's a few reasons, and they're not small, but it's a great point, Shelley. First of all, you're right. We don't know when the release date is on that person who's in prison already. So we need to have bail set on every single case. Two, we don't know if a person who's in prison for life may have their case overturned. And do we want to make sure that while that's happening, they still remain in jail for whatever crime they may have committed while they're in jail? Thirdly, everybody's got a right to bail. So we don't, even people who are convicted and lifers and looking at death row, they have the same rights if they commit another crime, and that is to have bail set on every single case. It also goes towards this kind of general approach that happens with prosecutors. And that is this, concept of belt and suspenders, that you can never be too safe. You don't ever know how things are going to turn out. You don't take anything for granted. And I will tell you a story. When I was a law clerk, not even past the bar, not even graduated law school, I was working in the major crimes division here in Los Angeles. Law clerks can do prelims, conduct preliminary hearings under the supervision of a DA. And I'm sitting there doing my work, which is a bunch of filing and making copies and a bunch of busy work. And one of the DAs says, "Hey, kid," I don't know if he said that, but that's how I remember it. "You want to do a prelim?" And I'm thinking, cool. Yes, I would. And it's on a death penalty case. I'm going to do a death penalty prelim? Not exactly. A death penalty defendant had committed a crime while in custody. And I think it was like drug possession. They tossed his cell and found some heroin, I think, inside of his cell. And they wanted to, and here's to my point. You would think the guy's accused of a horrific murder. They're pursuing the death penalty. What do they care about the heroin being found in this guy's cell? Well, they did. It's belt and suspenders. They wanted to make sure that, if things go sideways, he's not getting out anytime soon. So I sat there with a guy. I think this man had murdered, like sexually assaulted, raped, and murdered an older woman. I think it was horrible. I remember hearing the circumstances of it. But my case was, "Officer, what did you find inside of his cell?" "We found black tar heroin." And that was and he was convicted. And I think I even saved the prelim transcript. Don't have no idea where it is now, but it was like kind of my first experience doing a prelim. That was kind of fun. But to your point, Shelley, you never take anything for granted. All right. From Shelley in Northwest Florida. Where are we fueling up the jet and going to next?
Good evening, Josh and the CC crew. It is Helen the Scottish Llama here, who with a football stroke soccer chant stuck in her head. So if I'm not very with it, it is because I've got "We Shall Not Be Moved" going through my head all the time. Anyway, my question is that in Scotland, if you want to work with children, if you want to work with the elderly, if you want to work with any vulnerable adults, so disabled adults, you have to get what's called protection of vulnerable groups disclosure. And you don't have to be convicted of anything to be listed. It's just you're listed if you're accused of something and you seem to be a danger to children. And it's reciprocal with England and Wales. So what I was wondering is why the likes of so many teachers in the US can abuse children enough that it makes the news without something coming through and being said about it. And then you've got Andrew James McGann, who maintained his teaching license by quitting his job, and then
Helen the Scottish Llama. Love that name. Actually, you know what? I think you continued it here. Sorry. Let me get the rest.
Hello, this is Helen Scottish Lammer again, continuing on with my teachers and vulnerable people question. So Andrew, like the likes of Andrew James and McGann, who was able to quit his job without any sort of red flags being raised. How on earth does that happen when these sort of things protect the groups you are wanting to be protected, because they are the ones who are going to be at most risk of coming to harm from the adults in their lives, or the younger adults in their lives. So what do you reckon in the US could be done to stop the likes of Andrew James McGann, who moved across state lines and then maintained his teaching license, from actually being able to do inappropriate things or dodgy things and get away with it?
Helen, the Scottish Llama. First of all, let's put you on the map. Edinburgh, Scotland. We learned this last time you were on. She's saying 1 second. I don't know what's going on. We've got technical difficulties that are not even my fault happening right now. There we go. There we go. There's the map. Oh, everybody's relieved. There's the map. There's Edinburgh. There's Scotland. And there's where Helen, the Scottish Llama, lives. Okay, so your overall question here is, and you'd use the example of Andrew James McGann as an example, and we'll get into that case. But your overall question is, in the UK, you've got to go through all these background checks, and you've got to be certified, and you've got to be cleared to work with children. Why does this seem to be happening in the US? Well, I don't know if it's a US particular problem. I think it happens probably everywhere. But I will tell you, in the US, they have incredibly strict guidelines to work with children as well. I recently had to get fingerprinted and background checked so that I could even attend on-campus events at my eldest daughter's little kindergarten area. Like, not even to teach, but just if I wanted to go to a school parade or something like that and be on the campus, you got to get fingerprinted and background checked. Like, they take it incredibly seriously. And teachers as well go through extensive background checks. But these checks, they don't obviously reveal the inner demons of every person. And they only come up with what's ever in the system. And there's, I think, more the flaw. It's not the idea of, is there not a system? It's what's in the system. When you have someone like Andrew McGann, and let's get to him. So this is obviously the horrific, unexplained, random nightmare murders of Clinton and Kristen Brink at Devil's Den State Park back in July in Arkansas. They were stabbed while hiking with their two young daughters, ages 7 and 9. They actually have a third who wasn't with them on the hike. The dad fought him off while mom ran the children to safety, then returned to dad to try to help him. She ends up getting stabbed to death. And it's just nightmarish and out of nowhere and middle of the day and in front of their child. Everything about it just gives you chills. And then when we get down to who did it, this was kind of, a manhunt for a while. It's even more disturbing because we find out the guy used to be a teacher. He was a teacher for the 4th grade in Texas, for the 5th grade out of Oklahoma. And he had been under, he wasn't without discipline. Apparently he had been, had poor classroom management and professional judgment, whatever that means. He had resigned at one point in 2023 from one of his teaching jobs with no evidence of inappropriate behavior. And he had recently been hired in Arkansas. That's why he was there, to be a teacher. So, I mean, is this that no one spotted what was the evil under the surface with him? Maybe. It doesn't sound like he was doing a bunch of outrageous stuff that people were just sweeping under the rug. I think these school administrators and districts are so incredibly concerned with liability that they probably over-report stuff nowadays more than that. But did something miss it and get through the cracks here? I don't know, and I think that's one of the great mysteries of this case, that we're still trying to figure it out. And Afton says she thinks this was even his first Arkansas job. I think you're right. Just scary stuff. Or could it be that no one is at fault, that no school district is at fault, and that this person, which does happen, had some sort of late onset psychological unrest that caused him to just completely become untethered to reality and commit this horrible, horrible crime. So I don't know. Helen, excellent question. It's a much bigger and broader question than I am qualified to answer, certainly in a short period of time. Maybe it's a great question for us to bring back on Dr. Berry to talk about, though. But thank you so much for that. Esmeralda Weatherwax, great name. Thank you so much for becoming a member. Welcome aboard. You're going to enjoy it. Fala, damn it. Thank you so much for contributing the coffee to the mods. Appreciate you. All right. Let's keep it going here.
Hi, Josh and Courtroom Confidential crew. This is Erica from Hattiesburg, Mississippi. I am currently watching the civil trial for Abigail Zwerner versus the vice principal of the school she worked at. This is for the 6-year-old child that shot the teacher. I understand that the vice principal is also under criminal charges for that incident. So I was hoping you could better help me understand how it's possible that a civil trial could happen before a criminal trial, because if I understand correctly, in civil trial, if you plead the fifth, it can be held against you, whereas in criminal trial, it can't. If the civil trial is held before the criminal trial, doesn't that automatically set the defendant up for failure, because they have no other option but to plead the fifth, because anything they say in the civil trial would be used also in the criminal trial? Am I understanding that correctly? If so, isn't the fact that the civil trial is being held before the criminal trial kind of an absolute error and in reverse order? Hope that makes sense and that everyone had a great week. Talk to you later. Bye.
Love it. Erica, Hattiesburg, Mississippi. Let's put you on the map. Excellent, excellent question. I'm imagining Erica at the next I don't know, bake sale, fundraiser, talking with one of her friends about this subject, and all of it going over their heads entirely, because Erica, like all of us, is gets it, and we just have the smartest community on YouTube. That should be one of our little stickers, Kaylin, by the way. Erica wants to know, this is a great question, about Abigail Zwerner. This is the teacher who is suing her school district and her assistant principal. The assistant principal's name is Ebony Parker, because there was a school shooting. She was shot. She survived, thank God. But she's saying, I warned everybody. Now, Parker, right there, is being sued civilly, but she's also got a criminal case against her for the same kind of conduct. And Erica wants to know, well, listen, what about her Fifth Amendment protections? And doesn't that put her in a rough spot? And she doesn't, does she have to testify during her civil trial? And does she waive her Fifth Amendment rights? And how do all these things, these universes colliding, work? Well, I'm no expert on civil law, but I think it was Henry Ford, and I don't know if this story is apocryphal or not, but I think there was a story about Henry Ford, and he was being asked by the media, how does he feel qualified to run such a huge organization when he is not a highly educated man himself? And he says, well, I don't have to be an expert on everything. I just have to know experts, and I have to be able to have them at my disposal. So when any issue comes up, I call them and they can give me the answer. And much in the tradition of Henry Ford, when I have a question that I can't quite answer, I can always.
Hey, Erica from Hattiesburg. You wouldn't know it from my accent, but I spent a lot of time in Mississippi as a kid. And you are correct. In the Zwerner case, there is a negative inference that the jury or the fact finder can find against her for taking the fifth. That's true in the federal system as well. My guess, the defense made a strategic decision. You have somebody who's generally judgment proof, which is something you can Google, but we don't have time to address here. And you also have somebody who, on the other hand, is facing criminal charges and time in jail and a conviction. So they made the strategic call to let the civil case go forward, get a dry run, see what every witness is going to say, see how they're going to say it, see how they're going to present, see if there's any tricks up anybody's sleeve, and then they'll run it back on the criminal case if that's what they decide to do. Keep listening to the show. Thanks a lot.
That is my good friend and former co-worker, David Gammill. I've known David for, 20 something years now. We were hired together. We were in the same hiring and training class at the DA's office. There's his website. Please go check it out. Send him some love. Let him know that we appreciate him coming on and answering some questions. He also left the DA's office and he went into civil law. And so he is an expert in these issues. And he answers it absolutely correctly. This is an interesting thing. Yes, you maintain your Fifth Amendment right. So to your question, Erica, you never have your Fifth Amendment right taken away from you. But you don't have the same protections as you would in a criminal trial. In other words, usually to avoid this issue, judges will have the civil case trail the criminal case. Sometimes not. It's not automatic. You don't get an automatic stay. So for whatever reason, the civil case took place before the criminal case in this case. Not illegal. Nothing doesn't violate any kind of constitutional rights, but it puts her in quite a jam. You're right. Now, if she were to testify in her own civil case, or be compelled to testify as being called by a witness by the opposition, which happens in civil cases, what does she do? Well, she could testify, but now she's on the record and she's waived her Fifth Amendment rights, and those can be used against her at the criminal trial. Or she can invoke her Fifth Amendment right and not testify, and the judge will allow that to happen, but the judge could also instruct the jury that they, according to David's explanation there, draw an adverse inference from that. So civilly, you can comment on the fact that they invoke their Fifth Amendment and what exactly do they have to hide. Very, very interesting and very damaging from a civil perspective. If you invoke your right to not testify at trial in a criminal case, we all know commenting on that leads to an immediate mistrial. So thank you so much, Erica from Hattiesburg, for asking that question. Excellent question. Really appreciate the thoughtfulness. And then big thanks to my friend David Gammill. There's his Instagram. That's where you can harass him. Everybody said send David a nice thank you on his Instagram from Courtroom Confidential for answering that question for us. I appreciate it. All right. And to Chihuahua Mama, thank you so much for gifting a membership. Appreciate you. And who's next here?
Hi, Josh. This is Pam calling from Michigan. I have a question concerning marital privilege. Specifically in the Ellen Greenberg case, the ex-fiance, Sam, is, I think, currently married. If his wife knew information or found out information, is she allowed to go to the police and testify against him should she choose to? Or if they get ever divorced, could the police ask her questions relating to the Ellen Greenberg if Sam had ever talked to her about it or she found out information? Or just in any case, how does marital privilege work and what can the prosecutors legally use, not use in a case against a spouse that's under investigation. So just thought I'd ask that quick question. I don't think I've ever heard anything talked about this or not. So thanks for everything. All right, bye.
Pam from Michigan. Always love hearing from you, Pam. Thank you so much for all your support. Thank you for always asking questions. Let's put Michigan on the map. Pam, you really punched my geek button this morning because this is one of those things that I love. I love the hearsay exceptions. Can't believe I'm admitting this stuff to all of you. And I also love the privileges. I think these things are always very fascinating because they are strategic tools, and there's a lot of clever argument that can take place when you're dealing with hearsay and when you're dealing with privileges, and how can they be used and what arguments could you make around them. And the so-called marital privileges are especially a favorite of mine because there's two of them and they're a little bit different and sometimes hard to understand and not confuse. So first of all, we would know that none of these apply to Sam and Ellen. We should say first off, because they were not married, they were engaged. But Pam's question is, now that he is married, what about his current wife? And what if he is indicted? And can they use the current wife in any kind of way? So the first privilege that we'll talk about is the marital communication privilege. This protects any communications that take place within the marriage that are confidential, I should say. So if you're having a conversation with your husband or wife out in the open, screaming at each other at a restaurant, none of that is protected. But conversations you're having in private, in home, all of that is protected. And these privileges all have kind of a public policy reason behind them. We want to encourage the free flow of information between married couples, between a person and their a client, a patient and their doctor, a patient and their therapist, a client and their lawyer. That's why we have these privileges. This privilege can also be held by either spouse. So in this situation, Sam could say, I don't want her testifying. I hold that privilege. The wife could say, I don't want to testify. But it only covers communications. So that means if a wife were to witness her husband committing a murder, she can't talk about why he said he did it, what he said before and after, but she can talk about, and she in fact has to talk about, what she witnessed him doing. And this privilege survives the marriage. So even if you get divorced, any of those communications that took place during the marriage still fall under that protection. Then we have the spousal testimonial privilege. And that is, if you are currently married, you can flat out refuse to testify against your spouse. But that privilege is only held by the witness spouse. In other words, if husband is on trial for murder and they want to call wife as a witness, he cannot say, I don't want her to take the stand because of this testimonial privilege. Only she can say that. So she could say, well, I'm waiving that privilege and I'm going to go ahead and testify. But then he can say, well, she can't talk about anything we talked about during our marriage because he holds that privilege. And it applies. It's kind of more protective because it applies to all testimony. So if you are currently married, you don't have to testify against your spouse about anything you saw or heard or anything else. Again, the public policy behind this being we don't want a world where spouses can be compelled to testify against each other if they don't want to. But you have to be currently married. So it doesn't survive divorce. So if you are divorced, you better stay married to whoever you commit a murder in front of, is the moral of this story. Because if you divorce that person, they can go ahead and testify against you. You hear that, Tiffany? All right. Keep it rolling here. Where are we going to next?
Greetings and salutations and happy Sunday fun day to Joshua, Tiffany, Kaylin, Mods, crew, chat, everyone. Felicia K. Mayo from Humboldt, Tennessee. Joshua, let's talk about 39-year-old Jessica and 61-year-old Domingo Quintana from Liberty County, Texas. Apparently, in an attempt to flee the home or state, Jessica enacted Plan A, an attempt to flee the state with herself and her children. Failed one day. She went to Plan B the next day, and her children, ages 15, 11, and 6, agreed to drink a mixture of alcohol and NyQuil, and then she placed them in a pond next to the house, and she got in the pond as well. Now, Domingo rescued the children, and she was also rescued, and they all survived. But what I find fascinating is the children are now in the custody of other family members. So, Joshua, my questions are, what possible consequences does Jessica face? And do you know why the father does not have custody of the children? Look forward to your discussion and answers, and hope everyone has a great Sunday fun day. Bye.
AKM from Humboldt, Tennessee. Let's put Humboldt back on the map. There we go. Yeah, this one's a wild one. Thank you for bringing this one up. I had not heard about this case, and I'm glad Alicia K. Mayo is an avid reader of true crime news from around the country, always finding us those good little tidbits. And this one's a sad one as well. So this is Jessica Quintana. She's married to a man by the name of Domingo Quintana, who's much older than her, I think. I think even Alicia K. Mayo pointed that out. But story goes, she wanted to leave with the children. It sounds like they were having problems in their marriage. Apparently, the day before, he had taken away her keys and phone. He must have known things were getting bad. So because she can't escape with the kids, she takes her children, ages 6, 11, and 15, and makes them drink, along with herself, a mixture of tequila and NyQuil. Sounds like a hell of a cocktail. I don't recommend it. And with the idea, and even tells them, apparently, according to reports, that they won't feel any pain, with the idea that they will pass out, fall asleep, and she can push them all in a car into a pond that was on their property. They lived on a vast property with a huge home. Look at that home. And they're all going to die together. Murder, suicide. Well, Domingo comes home, sees what's going on, calls 911. Thank God, everybody is saved. 2 of the children are unconscious. One of them is under great distress, and everybody's highly intoxicated, including mom. Mom apparently nearly died herself, nearly drowned. She was in the hospital for 30 days recovering from this, but everybody survives. And she's now been arrested, charged with aggravated assault, child endangerment, a number of different felonies. But to Alicia K. Mayo's question, one, what is she, do I think, liable for? And why aren't the kids with dad? Why are they in some sort of protective custody right now? To that second question, I don't know if any of this, I have not read anything, and I certainly don't want to assume that somehow the father is responsible or in on anything. Sounds like they were just having really bad problems, and sounds like she's also suffering from some severe mental issues. But it could just be that, listen, these kids need to make sure wherever these kids are is in a very safe place, because they're incredibly vulnerable. And so I applaud that. That means taking some time to let the dust settle and figure out where these kids should live. Good. That's their job, and that's what they should do. As far as mom goes, I mean, we're going to have to learn more about this case, but you explained to me why this is not attempted murder. I mean, that seems clear as day to me, that her intention, had it not been through the heroic efforts of first responders, her intention was very close to happening, and that all 3 of those kids, including herself, would be dead. That's attempted murder to me. So I don't know why it's charged the way that it is right now. I don't know what other things they're taking into consideration, what other evidence they have, but Really, really sad case out of Liberty County, Texas. But we thank the lady out of Humboldt, Tennessee for that question. Thank you again, AKM. Great question. All right, guys. Take a deep breath. We're down to the final three. Don't throw things. Don't throw a fit. Don't get upset. We're going to survive this. We'll get through all of this, but we are down to our last three questions. But we've had a good time, right? We've talked about the Greenbergs and Abigail Zwerner and McGann and Wendi Adelson. Always a treat when we're talking about Wendi Adelson. We've covered a lot of stuff today. Shaffer, that case I had never heard of. Where is this going again? Brian Shaffer? What a mystery. All right, here we go. Who's bringing us home? 1, 2, 3.
Hi, Josh and everyone and Courtroom Confidential crew. Cat Flap Carnage here from Stilton in the UK. I had a quick question. What do you do if you're defending a client and there's literally no defense? All the evidence, everything points to their guilt, but the client doesn't want to accept a plea, doesn't want to plead guilty, etc. Do you just go to trial knowing there's nothing that can save the case? Just curious about that one. Oh, and I hope your little girl enjoyed her birthday. Thanks, everyone.
Well, that's very sweet of you, Cat Flap Carnage. Despite that name, you're very, very sweet. Thank you for asking. She did enjoy her birthday. It's, by the way, nowadays it's not just a birthday; it's an entire series of events leading up to that birthday. So she had quite a good one. Lots of toys, lots of happy times, lots of cake, and then it all culminated with Halloween and even more candy. So let's put Stilton, England on the map. Appreciate you for calling in. Good to hear from you. Great question. I love this. What do you do as a defense attorney and you've just got no defense? There is a long-held, I don't know what you want to call it, a word of wisdom or a truism, axiom that is carried by trial lawyers and criminal defense attorneys, and that is, if you've got the facts in your favor, you pound the facts. If you've got the law in your favor, then you pound the law. And if you don't have either the facts or the law, then you pound the table. And that's many times what it comes down to. Honestly, a lot of times this situation arises. Not always, but yeah, many times you'll have a case where there's zero evidence. I mean, I've handled cases just recently where, it's one thing if we could talk about, there was a problem with the search warrant, or, there's an issue with identification. But if you've got your client admitting to everything, how about that? They confess everything to police, and now you want to go put on a trial and you don't want to accept a plea. Well, that's your right. And that's the situation you could very well be sitting in. And that is not uncommon. That's a situation I found myself in before myself. What do? Is you protect their rights. You make sure that whatever takes place during that trial, that nothing is getting admitted that shouldn't be admitted, that there's no hearsay, there's no objectionable questions, their constitutional rights aren't being trampled. And you make an argument. You stand up in front of some people and so you say to them, listen, end of the day, the burden of proof always stays with the prosecution. They have to prove this case. We don't have to prove a darn thing to you. We don't have to ask one question. We don't have to get up out of our seat one time. The burden's on them, and I'm going to hold them to their burden, and I hope that you guys do too. And then you pound the table, and you hope that something turns out of it. But honestly, you hope to avoid that situation, because that's really not what trials are for. If that really does arise, you're hoping to somehow get a plea out of it. But thank you so much, Cat Flap Carnage. I'm going to have to ask you what that means one day, from Stilton, England. All right.
Hey, everybody at Courtroom Confidential. This is Bluebird 711, aka Lisa Nicole Shelton. Happy Halloween, everybody. Speaking of haunting, I watched a documentary on HBO that has haunted me since, and it's called The Alabama Solution. It features inmates like Robert Earl Council and Melvin Ray, who basically risk everything to smuggle out footage of beatings, cover ups, and deaths that the system buries like forgotten ghosts. Um, there have been 1,380 deaths since 2019, guards walking free after killings, and the dorms are so filthy, it is unfit for humanity. In 2019, Stephen Davis was beaten to death by officers, and his roommate, James Sales, hinted that he would tell the truth to Davis's mother once he was released for his own safety due to all the corruption, only to be killed a month before his freedom. The state profits huge, 250 million in garnished wages since 2000. And I am just curious. I have so many questions about this, but I guess if these incarcerated activists can defy the odds from the inside, what is our excuse from the outside? And do you think this solution is just Alabama's dirty secret or a mirror to a national crisis waiting to explode? I would love your take on this. I think it could spark some real reform, or are we all complicit to?
Lisa, Bluebird, 711, thank you so much for the excellent question. If you're in the chat, I appreciate you. I just have one question for you, and that is, where are you from? Because I didn't hear your location, and I tried finding it, but as soon as you let us know, we'll put you on the map. But in the meantime, you raise a really important point that, again, it's one of those things where I don't know if I'm even nearly qualified to weigh in on it. And it's certainly not something that can be answered quickly or even if you had a lot of time. I think it's just a horrific issue. The short answer to it is yes. Does there need to be reforms? Absolutely. Are there problems and troublemakers? 100%. Is it a wide sweeping across the board, no good guard in America? No, absolutely not. I know I've some close friends of mine. When you work in the sheriff's department here in Los Angeles, and I have many friends who are in the sheriff's department, they start you off in the jail system, and they run the entire jail, and they deal with inmates, or incredibly violent people, very bad conditions, all of that. And they, I should have one of them on as a guest. They can talk to you about how difficult it is and violent and, trying to do their best. And are they good guys trying to do good in a horrible situation? Yes, they are. Does that mean that there's not bad eggs amongst their group? Absolutely not. Does that mean that there are people who take it too far and abuse inmates? 100% that happens. And is it a systematic problem as you are concerned with, Lisa? I think it's certainly a problem that there is no county in this country that should say we've got that problem solved. Put it to you that way. I think it's certainly a question that every county and prison system should be constantly reviewing whatever they're doing to make sure that they're avoiding this. I have not seen this documentary. It is, I know it's on HBO, and I've seen it come up in the list of suggestions for me, but I am going to watch it, and I appreciate you, and I implore everybody else to watch it because it sounds like it is really, really eye-opening. So thank you so much for that. Lisa, did we find out where Lisa's from? Where is that? Zoom in for me. I got bad eyes. I'm an old man. Waddy, Kentucky. Thank you, Lisa. And thank you, Kaylin. Kaylin's screaming at me over the thing. She's screaming Waddy at me. I can't lip read either. I'm an old man, I said. All right. You all have been fantastic. You're all wonderful. You all asked incredible questions, and you're all part of the smartest community on YouTube. But we've got to bring it to an end here. We got our last question. Who's going to bring us home?
Hello, Joshua and the Sunday Fun Day crowd. This is Kay from Red Bluff, California, calling again for the third time. watching the Donna Adelson trial, said that she received Social Security. Will she continue to get Social Security when she's in prison? Or do other older inmates, do they get Social Security? And I was also thinking about retirement accounts. Do they get that? Do they receive those funds in prison? And can that be used towards restitution to their victims? Thank you for educating us. Bye.
Kay. Oh. I think Kay from Red Bluff, California. Let's put Red Bluff on the map. Oh, is that Lake Tahoe? Oh, it's way up there. Way up there. Kay, thank you so much. Great question, says Shell. I agree. I didn't know the answer to this. I didn't even have a clue. In fact, my first guess was, yeah, why shouldn't they? But they don't. And this is according to the Social Security Administration website. No, if you are incarcerated for over 30 days, your Social Security benefits are suspended. And that makes sense, I guess. Social Security is supposed to protect people from, running into poverty issues when they're in their retirement years. And it's not like Donna has to worry about food and shelter nowadays because she's going to have a roof over her head and she's going to be provided with 3 squares a day. It's just they're going to be a little carby for her liking, but that you would understand why we wouldn't also want the federal government cutting her checks while she spends time in prison. So that makes sense. Interestingly, though, if you have eligible dependents receiving some of your Social Security benefits who are not incarcerated, they do continue to receive those. Also kind of makes sense. And if she's ever released, or if anybody's ever released from prison, they can have those benefits reinstated. So something I never would have thought about had you not asked the question, Kay, and I appreciate you asking the question, Kay, but I don't think the Department of Treasury is going to be cutting any checks to Donna Adelson anytime soon. All right, guys. Wonderful Sunday fun day. Thank you so much, everybody, for the questions. Don't go anywhere. I'm looking at the numbers. Everybody, keep your fingers off of the keyboard and sit tight. We have some announcements for you. But before we get to that, we do have a word from our sponsor. I don't know if you've seen the news lately, but there are reports that over 183 million email passwords have been leaked online, including Gmail. This means that hackers can not only get into your Gmail account, but they could get into any account linked to that account, including shopping sites, banks, and subscriptions, you name it. As someone who uses Gmail every day, I worried, obviously. But then I remembered I'm protected by our sponsor, Aura. Aura provides full digital security so you can feel safe even when leaks like this happen. You get dark web alerts, bank fraud monitoring, a VPN, antivirus, a password manager, and up to $5 million in identity theft insurance all in one app. Try Aura free for 14 days right now. Just go to aura.com/courtroomconfidential. It's free to try, it protects you, and it helps support the show. We really pride ourselves on Courtroom Confidential for whenever we're doing a live stream and it's happening live, we don't ever want that to be interrupted by ads. And so that's why we have a sponsor, so that you don't have to sit through those YouTube ads while you're watching these live. So please check out Oro. They're doing us a huge favor. Have you heard about our website? It's called thecourtroomconfidential.com. You can open up a new web page right now and go to thecourtroomconfidential.com. And what are you going to find there? Well, first of all, if you've watched Sunday Funday and you say, well, I had a question, he didn't get to it, I wanted answered, you can leave us a message by going to thecourtroomconfidential.com and click on that red button there to the side that says leave us a message. And you can leave us a message with whatever true crime question you've got, and we will answer it on the next Sunday Funday. Also, a lot of people gifted memberships today. We are so grateful to all of you, including Southern Cali B says, Josh, before you go, can you comment on Matthew Paul's defense lawyer? True. I don't know this answer about Matthew Paul's defense lawyer. I'm missing something. Here's what I'll do for you, Southern Cali B. I'll look it up and I'll find out. And if you remind me, I will answer your question next time around. But thank you for asking the question. Josh Girl says, so if Sam told his wife he killed Ellen G., she can't testify whether married or not. If Sam told his current wife that he killed Ellen Greenberg, correct, he can prevent her from testifying. If he said that to her in a confidential marital communication, he can prevent her from testifying to what he said. If she's witnessed him I don't know, reenacting it, then she could be compelled to testify as to what she saw, but she can say, I don't want to testify against him. I don't know. I'm making this more confusing, but yes, Josh Girl, you are correct. Memberships, that's where I was at. If you want to become a member and you're feeling left out, we do a lot of work to make our membership program something that you guys will enjoy. Go to thecourtroomconfidential.com, click on become a member. You can find out about all the different levels and all the benefits that we have. And we just had on Saturday our quarterly Zoom call with our For Your Eyes Only members, and we had a really great time. It was a great conversation. Great to see all of you who are in the chat today. And then finally, merch. If you would like to buy some of our merch, including this, is this one of the new shirts? I think it is one of our new colors. This color that we have, plus plenty of others. You can go to the shop at thecourtroomconfidential.com. What is it, Tiffany? What are our guesses? I see a rosebud. I like that one. Roasted tomato, rebuttal rose. Clever, Afton. Very clever. I love this shirt color today too. Anya says she loves it. I love it too. It's one of my favorites. I'm going to wear it a lot. Bench trial burgundy, says Afton. Afton's on fire, everybody. Michelle Crawford says sun-dried tomato, kind of along those lines. What is it? Tomato salmon, pomegranate prosecution, says Shy Gal. I like that a lot. Roasted tomato, says Pammy. What is it, Tiff? Tell us. I think I actually remember the name of this one. YouTube Bad Actor says Ritter Rose. I'm going with that too. It's brick, everybody. He's wearing brick. But it's a beautiful color, and it's from this company that we get all of our colors from, all of our shirts from, and they're really high quality and comfortable. So go check it out. We got a bunch of new colors up there. And we're going to be retiring some colors soon. So we'll let you know which ones those are. All these announcements are going to be taking place in the next week or so, because we're making room for our new holiday merch to be announced. Some of you may have seen it already. Really fun stuff, including some holiday themed items, but also brand new mug. One of my new favorites. Says what's happening here on the back, just so everybody at the coffee shop knows entirely how confused you are. Brand new mug with the inside coloring. And we got tumblers, and we've got Let's Get Juice, and we've got the wine Pinot on the Grow tumbler, and a bunch of different shirts and colors, all a bunch of fun stuff. Please check it out. The Christmas is coming up soon. Now that we're done with Halloween, we're in the fast lane to Christmas, and we wanted to make sure you guys had some interesting little giveaways for all your friends. All of that's at the website. Finally, what did you miss Saturday? Well, you missed the Zoom call, and you can catch it next time around if you become one of our members. But you also missed from on Friday, we had our weekly roundup where we talked about Tyler Robinson, DeCarlos Brown. Is that Pierce, David Pierce there off to the edge? Who else? Abigail Zwerner. I don't think that's her. Is that Abigail Zwerner in the picture? I don't think that's her. Lot of interesting cases from this last week. So weekly roundup every single week at Friday, live at 2 p.m. We cover everything that you may have missed that week. Then, it's Maya Kowalski. Yes, big update in that case. You guys should check it out. Then tomorrow we do the opposite end of that. We bookend your week. So on Mondays, we tell you what's coming up, and Fridays, we tell you what happened. And this Monday, we're going to be covering our true crime docket coming up tomorrow night at 5 p.m. Pacific, 8 p.m. Eastern. Some things happening this week. Courtney Clenny, Barry Morphew. What is her name? Shoot, I'm blanking on her name. Oh, it's going to come to me. It's driving me nuts. Laken Snelling. All of these people will be in court this week. A lot of interesting movement on the Barry Morphew case. Some of it not so great for us in the true crime world. And then Wednesday, we will have our, at 5 p.m. Pacific, 8 p.m. Eastern, our Wednesday Night Live, where we it's your midweek catch up on all things true crime. Finally, CrimeCon, way in the future, next year, in fact, May 29th through 31st, CrimeCon is coming back to Las Vegas. We're going to be there. Would love to see all of you there. And if you need just the smallest nudge to get you there, then we can get you a 10% discount on your tickets. When you go to checkout, enter the room, courtroom, all caps, all in one word, to get 10% off for CrimeCon coming up this May. I think that's everything, guys. I thank you so much for sticking around. What an incredible World Series. Now we're on to football. It never ends here at the Ritter household. Enjoy your football today, guys. Enjoy your Sunday. Follow us on Facebook, Twitter, and Instagram. Thank you so much to our wonderful mods, as always. Afton and Sonia, Kathy, and Therapist, you guys are fantastic. Couldn't be doing any of this without you. Thank you for keeping us all in line. Kaylin, you're the best. The queen of B-roll, keeping us on top of everything. Big thanks to David Gammill for his help with the Phone a Friend today. And as always, Tiffany, thank you so much. You're the best thing to ever happen to me. Thank you, guys. Have a great Sunday. Take care.